Hey YouTube, I am here. We are getting started and just giving some time for everyone to come in and make sure everything is set up. So, Hey, if right. I was on mute and didn't even realize it. So, welcome to my channel, Bama Girl 2.0. Um, on this channel, we kind of first of all, we're going to be covering this YSL case. We are a community um that is aligned with the progression of our community through thought provoking discussions and engaging content. We will foster meaningful conversations. We use current events, true crime, court trials, and research to spark conversations. This safe space aims to inspire confidence in your own personal power by discussions on organizations such as the justice system in this country, state employment laws, crimes against the community are welcome. I'm sorry, etc. All are welcome. Come as you are while we explore the complexities of life. I am grateful for your presence. And I mean that sincerely. So, um, I am covering this trial on another channel, Break Bread with Duchess 2.0. That is my channel that I kind of review a lot of TV related stuff, relationship kind of things. We spark conversations based on the characters and the representations that are present to us. Excuse me. The channel is doing pretty good. I just started a couple months ago. Yeah, I'm tired, but we got to get this done. So, I just started a couple months ago. I have a lot of things going on in that channel. It is confusing the algorithm, and I can tell how it's kind of happening. So I needed to break things out, and it's the all the things that I want to cover is just too much to put on what channel. So I don't want the audience confused and all of that. So yeah, we're gonna get into it over here. So tonight, I wanted to kind of get into just a little recap. We will be going back to live court tomorrow. Everyone needs to be in. She wants them in at 8, so I'll start over here at about 7:45 in the morning, just to kind of cue things up and get things ready. The jury will be returning back tomorrow. We have been in kind of like a him ha state. There are a lot of motions filed for mistrial. There were some motions filed to kind of get rid of the DA and all of that. And the rulings came, there wasn't any court on Friday, and the rulings came down on Friday. So there has been more motions filed, sort of to speak. I suspect there will be more things that come up. So I wanted to kind of recap because in the judge order and um her denying the motion to get rid of the prosecution team, she gave some orders and some rules. And in another motion, she basically declined everything, but she's sending them to training, which is odd. And I wanted to kind of get into that commentary. I have some thoughts on it because I'm looking at it from, I mean, definitely we are concerned about the injustice of it all and how the system is just really kind of playing in our faces. But at the same time, I need to put a comment up here. Let's see. Yeah, I'm not fresh, right? I just hosted a live. It was 2 hours. So please, please, please bear with me. Tomorrow will be much better, I think. I know it will. Um, so let me just put this up here because I just realized something and I don't want any strikes. Okay. So I'm looking at it from a I'm looking at it from a different perspective, right? Yeah. I'm looking at it from a different perspective. I definitely over how they kind of played in our face, but I don't think she really had much of a choice. And so before we get into her rulings, I wanted to kind of recap on one of her videos. One of the videos that we just did of the live coverage. And so I think that her ruling, she's kind of acting like an employer. And I am looking at the district attorneys as employers of the state. And so she mentioned in her like she mentioned in court, which is kind of like when I knew that this wasn't going to go the way that everyone expected it to go. She mentioned in court, like, listen, they want us to it to kind of be a last resort. It needs to be very drastic. Um, and considering they haven't had any corrective action, really, like it will also be like I think that they can get into some employment gray areas. And I'm starting to see the judge as kind of like a real life manager in the courtroom that has a lot of power that has been flushed out, but she also has to act as an employer for the state, and they are employers, right? And so I still think that there's a win there, but it's a long-term win. And I don't know if the state can stop the practices that they have been doing because it seems like something that is ingrained. Like one could argue that they don't even really know, but it's so blatant. Like, how could you not know? And according to some of the attorneys, it's kind of like lawyer 101. So, before further ado, I just wanted to kind of look at a few things that where the judge is sort of doing some correction. And so we're gonna go. This is a live that's on my channel. Let me give y'all a little plug here. Let's see if we can do that. Break Bread with Duchess 2.0. That's where this live is kind of like hanging out at. Let me go over here and get a link. So I can drop it down here. You know, I just want to be completely fair to myself. We want to do that, right? So let me go over here and get the link to that channel and drop it down in the comments. I mean, if you want to give your girl 2 subscriptions, to subscribe to both for both type of content, I'm here for that. That's the reason why I'm here. I am here for you guys. Okay. And I also have a little fun competition that's popping off over there to get the subscribers up and to, just kind of get some more traffic and really, really grow the channel. So here is the link. Should you like to subscribe and get into some of the TV stuff that I'm into over there? Child, the jury is out on a couple shows, but definitely the Braxtons, I am here for it. For sure, that's my jam. I'm so glad they're back. It's quite a few other ones that I review. We just finished up with Sisters. The family business is going on over there. I don't know if y'all are into um Big Brother, but I'm into that too. I got to catch up on it. It came on tonight and I'm not even watching it because I thought it was very important to kind of cue us up for tomorrow's court day, and I needed to, excuse me, y'all. I needed to kind of carve out this type of content from that channel and get ready to start breaking things off. So hopefully this works. Otherwise, I've got myself into a little pickle over there. I mean, and y'all can help me out. So let's get into this case. This is from Court Day 106, and I have some time steps that we're going to get into. So we are first going to start at 437. So let's see.
There are, two general grounds. We've addressed that in a previous response.
All right, y'all.
But not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify. And there.
Okay, so let me stop here. All right, y'all. So in this argument, the state is responding to the motion to disqualify them. So she is giving her argument on that issue. So I thought that would be fun to look at. So let's get into it.
There are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77.
Here, just a quick pause. So it is interesting to me, like, this is why I feel like she's acting as an employer, the judge, because here is this district attorney that's been prosecuting this case for 108 days, and her colleagues want her fired, rightfully so, and we're going to get into that, right? But she is, she has bullied this entire trial, has been so inappropriate. Do you know how humiliating this is for her to have to stand here and argue to not be kicked off of the case? Like, I think that there are some wins here, but we just have to look at it long term. That's my opinion. Feel free to come in and kind of let me know where to get off at. But I have been an administrator for a long time, a senior leader in senior leadership in healthcare organization. Completely gotten out of that, but I'm looking at it from this lens, and that's interesting to me. So let's get back. I just wanted to bring that point in.
Finally, the court held that a party did not have standing to base a motion to disqualify an attorney, to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest, where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. So that interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify. And if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shark's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shark's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shark's amended motion for a fair trial. So
filed Friday.
Yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
Okay.
All right. So we're going to mosey on over to timestamp 15:15. Because what I'm doing is I am just showing kind of like examples of the ways that she's kind of had to teach them and educate them at the same time. And you'll see the judge kind of get a little frustrated with the state, but to me, it's trying to keep the entire team on the right path, so to speak, like coworkers fighting kind of thing. And so I just wanted to kind of look at it from this lens. So let's go to this clip.
Same position as Mr. Matthews, Your Honor.
Okay. All right, so I've got another question for the defense, and that is, I think that everyone has joined into the assertion in both of the pending motions that I mentioned before that the
I apologize for interrupting the court. I think there was one more party that.
William Stillwell, Kendricks, Huey Ryan. Oh, guess, I don't know. Sorry. Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it.
Okay.
We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding.
Okay.
And number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
All right, as I mosey on over to another clip of where she's kind of schooling the defense, really. The prosecution team, and then we'll get into some of these motions. This is when I knew that she was going to bring the jury back. Like everyone was so heated when they learned of that second ex parte meeting where the judge was disparaging the defense attorneys and showing his bias, saying that he knew that they were guilty and playing in their faces, so to speak. I'm paraphrasing, and offered to meet with the prosecuting attorneys on the weekend. They told the court reporter they know that there's no court reporters on the weekends. So the judge was kind of like, this is on June 7th. They never even disclosed this to them. And the judge was acting as if he was part of the prosecution team. It was awful. And the attorneys were really upset and they filed all these motions. The judge was already recused, but they're wanting her to handle business and how the prosecution team has violated these clients' rights and misrepresented and all of this stuff. So the motions have kind of been out there. She told them that we're just going to kind of go through these evidential hearings and keep things on board until she gives her ruling, just in case. But she keeps saying the jury's coming back on Monday. The jury's coming back on Monday. So this is when I knew that she was going to keep this case going forward, despite all of these imperfections. So, and we're going to move to the next clip, which is about the 38, maybe like the hour and a half mark or so. What I'm doing is I'm just kind of showing where she's taking out all the violations, showing where she's acting as an employer. So when we get to her order, I think it makes sense, and I don't necessarily see it as a loss. I see it as, all employers of the state. So let's get over there and keep this thing moving.
Totally redactions, and there are some that I agree to.
Okay.
Not a lot, but we've already given the court the first one. Does the court have a copy of this redaction?
Yeah, the proposed reduction, yes.
Okay, so looking at Mr. Sharp's chart, number one, we've already discussed, number 17 is.
On to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
I mean, just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line. You can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it just
How would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it out.
don't,
Strike it. Granted.
yeah, okay.
All right, I'm just writing August 6th, 2024, Courts Exhibit 1, as to this 3-page
Yes, Your Honor.
proposed reductions. Okay.
So the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32.
All right, Ms. Lett, what do you have to say about that?
We had line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Monktunk, Demikian is in the back with you and Shannon is in front, and then and then Mr. Zachary says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindarius Zachary about activities that YSL and rivals are sort of involved in. Mr. Dennis talks about how they thought it was kale, and Mr. Zachary says, no, he corrects them, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count one in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
No, line 17, where he says they tried to say that we did it on on page 33.
oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish,
The existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
all right, Mr.
So,
Sharp?
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you, if you don't mind.
On this
It
alleged,
moves, so you can just move it up on your desk, maybe, I don't know.
with
I
this-
know, they're all annoying, they get in the way.
with this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay,
This is a gentleman who, you know, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't have, I mean, I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming
Mhm.
existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purpose of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 15-026-2801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an
that's,
associate of YSL and a member of YSL aren't the same thing.
they aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it. Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about
All right, let me,
so if gang is the gang that
so
they're
is that the they here? This is the
associates
part of the gang that
yes.
there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? And if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant, and it confuses the issues.
And if the court goes on further down,
Mm-hmm.
and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say, is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right. So
He's literally saying, no, that didn't happen.
right, but she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you know, you and whomever were involved in this shooting with the, you know, whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other words,
says
don't
something
try to
different,
get
you're like,
him, don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Okay, so 13 is the end of the Rich Homie Kwan
Right.
barbershop. And then they
Yes.
start talking about Tay shot Kel.
And
I don't again, I don't represent Tay. Tay's not associated. So, but it's just I just think it would be confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right, who's dead and not on trial here, right?
That's true. Unfortunately.
Okay, so is it relevant?
In it,
Get a judge.
I mean, I would assume you want
No.
a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
yes, it goes over into page 40. There's a video that we're gonna have about with Quindarius Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is Ifgang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mm-hmm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're going to introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, I'll take it out.
We'll take out. So it's going to be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what now?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary.
We don't.
Saying his understanding was that Kel shot up his girlfriend Trevia's house.
right. Hang on.
So-
Ms. Love.
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Entrevia's house, that part is correct because Entrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that that would be relevant. It's not, it wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Entrevia Smith's house got shot up.
Mm-hmm.
It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevious house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevious Smith's house. Mr. Zachary was not shooting at Trevious Smith's house or being shot at Miss Smith's house, Trevious Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shelkel was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Excuse, Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right, let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe
I'll be
get
right
back
back,
to
you guys.
us on this one.
Yes.
Okay. Because I mean, I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
And that's all the way through 42.
All right. So,
Brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of.
Okay, so just a quick little thing. What they're talking about here is Lil Woody is going to come back. They brought Lil Woody back into court to make sure that he understood his previous testimony will be completely wiped out. And some of the coercion that they used in their ex parte meeting with the previous judge that has now been recused is that they told Lil Woody that if he pled the fifth after they gave him immunity, that he could be held in contempt and thrown into jail. They also told him that he would have to stay in jail through the duration of the current trial, plus the 20-something defendants that are still left to be tried, which was not true. and illegal. So that's what she is arguing against, because she wants Judge Whitaker to handle little Woody in the same manner. And she's explaining to her why the law says she can do it like Judge Glanville did. So I just kind of wanted to put some of that into context as to what they're talking about. And I'm going to get back to these proceedings. You can find this entire case on Break Bread with Duchess 2.0. This is day 106 of the Lil Woody, where Lil Woody takes the stand. And I will be continuing to cover this case on this channel to kind of break out some of the content, because I do a lot of TV reviews over there and I'm confusing the algorithm. So just a little context there. This entire live can be found over there. And I will be back here tomorrow morning on this channel covering this trial, because the jury comes back Monday. And I just kind of wanted to catch up. So anyway, back to this, just so you kind of know. So,
Of the contempt by testifying.
a little bit.
It'll just take me a second to get it in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available. I'm
It was not going to be available at, I mean,
not at that trial.
right.
Yeah.
So I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
No, I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified, the last time, Judge Glanville, I think, gave him a copy of
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think.
In court.
Yes,
Okay.
he gave to Mr. Copeland, read to him or gave it to him a copy of the statute and apprised him. I think he made
Okay, right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive. So
what were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03, and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, The example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it, and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but
Yeah.
I mean, yeah, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions, and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the
And I can then take it all and look at it and
Sure.
put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given.
because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I
okay.
haven't fully got it. It's in re Long, 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. That answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
And in re and it's a 2005 case there, so I haven't looked carefully at it, so I don't know if it's cited in the annotations.
it is for a different proposition. I haven't read it myself either, but maybe the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example.
Okay. So again, this full day of court is available over on Breaking Bread with Duchess 2.0. I have pinned that in the comments here. Let's see here. Here we are. All right. Bread with Duchess 2.0. And so I just kind of wanted to give like some background. Like if you can see, like they are working together. Like she is kind of teaching her. She is the prosecuting attorney, the lead prosecuting attorney on this case. And there is a lot of arguments in the evidence that she wants to submit that she would have gotten in under Judge Glanville. There's been all kinds of tricks and things. And I just kind of wanted to show how the judge is almost handling her as if she's a new prosecuting attorney, right? So let's get into her ruling. Let's get into her ruling. Let's see which one we're going to do. All right, so we're going to get into, let's see if that works. Yep, it did. And I'm going to make this kind of this way. Let's see. All right. All right, let me move that comment off. And I wanted to kind of make this a little bit bigger. Go back. Okay. So, this is the judge's order on defendant Stillwell's renewed motion for fair and constitutional trial. So we got into the reason for that additional motion. We talked about the June 10th ex parte meeting with Judge Glanville and Kayla Bumpus and all of that. They learned that there was also a June 7th ex parte meeting that was just worse. So, and it was clear that the judge was biased. Judge Whitaker's position has been Judge Glanville is no longer on the case. The attorney's position has been the clients, although he's no longer on the case and we're kind of fixing it now and getting things in order now, our clients are due a fair trial from the beginning. And these attorneys have done all this stuff that have not been appropriate. So this is her order on defendant Stillwell's renewed motion for fair and constitutional trial. Defendant Stillwell raises numerous assertions of error, impropriety, prosecutorial misconduct, and judicial partiality, which he asserts have resulted in a denial of his constitutional rights to due process and a fair trial. The pertinent determination is whether such events, if they occurred as alleged, warrant a mistrial with prejudice, dismissal of the indictment with prejudice, which would have the same effect, or disqualification of the prosecutors. Claim 1. A plague of discovery violations, missing police reports, and Brady violations, discovery is being addressed. The court has ordered that the state to timely produce all discovery and undertake a concerted effort to secure and provide all police reports, including asking current APD personnel with specificity to search for and produce reports on the case. Again, y'all, we're in day 108, and these people still don't have this information. But she has addressed it and has been very firm. As recently as the court proceedings on Friday, August 1st, 2024, the court confirmed the state's understanding that Brady obligations include the disclosure of material impeachment items and reminded the states of its continuing obligations under Brady. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Now, this is important. Y'all, this is important. And I may be too late in this live to kind of address this part. And I probably may not have done this correctly to get to this point. But I kind of wanted us to see how we got here in support of what I'm going to kind of comment on. So I feel like this is important, y'all, because as an employer, when there has been infractions, you can get yourself in a wrongful termination lawsuit. You can get yourself in Fair Labor Acts and all this kind of stuff. And the prosecutors are employees of the state, right? These are government jobs. And so she mentioned in the trial, I'm sorry, not in the trial, but in these kind of like hearings that it has to be extreme circumstances and they really want us to do our due diligence. So what she is doing, this is kind of like it's almost like a write-up. Because she's saying that they understand, the court confirmed that the state's understanding that Brady obligations, including the disclosure of material impeachment items, and reminded the state of its continuing obligations under Brady. So she's given them some warnings, some verbal warnings, some written warnings, and she's putting this in writing. This is a reprimand in writing if we look at it from this lens. This means that as this trial goes forward, the state doesn't have any more wiggle room on the things that they've been doing. She told them the next 30 witnesses that they have, they need to have all of that in front of them. Anything that you may think that may be, it has to come up here, not in front of the jury. This is why I say I kind of want to see them go forward with this, because I think these attorneys are going to eat them alive. They've introduced another attorney in the playing field, smartly so. But anyway, back to this. The state represented to the court that it has fulfilled all its Brady obligations. The court will address remedial Brady action later in this order. Remedial. So they are state prosecutors on 108 of this trial, day 108 of this trial. And they've done all kinds of shenanigans, y'all, under this other judge. I think she's done a good job of reeling in the temperature of the courtroom, kind of got everybody playing ball the way that they should be, arguing their points, arguing for their clients, that kind of thing. Like I kind of understand it. Yes, we wanted all those things to happen, but there are employment laws too, and they are employees of the state, and that's kind of my point. Claim 2. Prosecutorial failure to follow court orders, making a specious allegations against defense counsel and counsel for a witness, and lack of candor to the court. She did do that. They even gave her a warning. Any past failure to the prosecutors to follow orders of the court is a matter of record. Aside from the broad assertion of a denial of defendants' rights to due process and a fair trial, no specifics establishing this assertion and no claim of resulting legal error is alleged. Any potential error stemming from prosecutorial failure to follow court orders may be addressed on motion for new trial and or direct appeal, assuming any conviction. Okay, so I'm going to pause because this is the part that I don't like, right? All of the parties are innocent until proven guilty. Y'all done had these guys put away for 2 years. This has been going on for 2 years now. And I could be exaggerating, so we're going to say 18 months to 2 years on allegations. So if these were lay people that didn't have resources, their lives are already just like upside down. So, with all the things that they've endured and everything that has happened and all the ones that have stepped in, I would think the fair thing would be to kind of free them up and let them go. This isn't their fault and they're supposed to be innocent. But their options are based on this is you're going to continue with this trial and stay in trial. I am going to make sure that it moves on along. I mean, and if it's not done right, you have the option to appeal and do it all over again. Assuming there will be any conviction. I don't think they'll be able to get a conviction on the evidence and all of that because it's shaky anyway. But anyway, that's just my little part on what I don't agree with. But I do understand why she's handling the prosecution the way that they are. Any special allegations against defense counsel, counsel for a witness, or lack of candor with the court is, at minimum, extremely unfortunate. These items do not, however, establish a denial of defendants' rights to due process or a fair trial, and the court at present declines to impose the extreme sanctions of removal of any offending prosecutors. 3. Improper evidentiary rulings by predecessor judge. A defendant is entitled to a fair trial, but not a perfect one. Wow. For there are no perfect trials. She cited case law. Evidentiary error, which involves mistakes under Georgia's procedural rules and evidence law rather than any constitution violation, ID, can be addressed in post-trial review. A subnote. The court reminds all counsel that every Georgia attorney is bound by our rules of professional conduct and owes a duty of candor to the court. These ethical and professional obligations should be scrupulously honored, and prosecutors, above all, should endeavor to comport themselves so as to be above reproach in such matters. The court understands that it has the authority to sanction counsel for violations of the rules of professional conduct that occur during and impact on a case before this court. The court declines that invitation at present. However, any future persistent failure to abide by the rules of professional conduct or lack of candor with the court may trigger the extreme sanction of removal from case. The state's June 7, 2024 motion for immunity and compelled testimony of Copeland states, on Thursday, June 26, 24, after an encounter with defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland might attempt to plead the fifth in order to avoid testifying against members of YSL. Even assuming that this is a willful misrepresentation as opposed to inartful drafting or a misunderstanding, the gravamen of the representation is that Copeland had, the gravamen, child, is that Copeland had indicted he might plead the fifth to avoid testifying in this trial. The sequence of alleged events is not the material aspect of the motion. So it's kind of like she's grouped everyone as a reprimand, but gave a special mention to the state. The state does have zero room, right? But maybe. But it also allows for the state to play on the defense attorney's tops, which the defense attorneys have been doing nothing but advocating for their clients, and the prosecution is the ones who have done all these infractions. So why is there a reminder for everyone? But in saying that, there has been some instances, where it has gotten pretty heated in this trial, if we're honest. And although their emotions and their reactions may be justified, I think that there's still room for both parties uh, to kind of get this warning, because even though it's justified, they're expected to kind of maintain their professionalism. They're human. She understands it. She even, you know, there was a point where attorney Love was like, well, attorney, they've been doing it too. And she said, I understand. I mean, if someone had accused me of what y'all accusing them of, I would be upset too. So I understand. But I think so that the prosecution team can't say that they were being treated unfairly and the judge showed bias to the defense team and all of that. This is her way of kind of navigating that, as if she's dealing with an employee issue. They talk about her having the power to, put sanctions, excuse me, and impose sanctions and remove them from the case. That's operating as an employer to me. And I think the camaraderie between, all parties, that they are so accustomed to functioning as a team, that this is kind of spelling out that there is a hierarchy, which is the judge, and the judge has some power to ensure that they're all behaving accordingly and can do disciplinary action. So I get it. It's just unfortunate for the clients, but at a minimum, they got enough to get a mistrial or get, whatever. Like, it's if they appeal all of this mess, it would be more than enough. Um, but it's just unfortunate that they have to kind of continue to sit through. So that's kind of like my piece. All right, claim 4: mistreatment of defendants and their counsel by the predecessor judge. Aside from a blanket assertion, the motion does not detail any alleged mistreatment of defendants. The alleged mistreatment of defense counsel detailed in blank is not alleged to have occurred in front of the jury, and even accepted at face value would not rise to the level of violation of defendants. Due process or fair and trial rights as to remedies to the predecessor judge has been recused, and the contempt issue outlined in his is mute. Okay, I understand what she's saying there. They had this this bonus ex parte meeting on June 7th, right? It was in the judge's chambers. They made a bunch of disparaging comments. He was clearly biased. It was clearly all the things that happened that they didn't know and all of this stuff, right? As far as she's concerned, it's been fixed. He's no longer on the case. We have spent a couple of weeks going back and forth, bringing in evidence, taking out evidence. I've overruled some of his stuff. We got it kind of fair and on track here, and we're in the thick of this thing. So it didn't happen in front of the jury. If the jury's not watching the media, they don't even know that this happened. He did call Steele unprofessional and unprepared. They're going to give a statement on that. But the judge is no longer there. When they come back, they're going to have a whole new judge. And that didn't happen in front of the jury. Is that the law? Are there things that need to be changed in the code of conduct with Georgia's law? Maybe, in their code of conduct and what it constitutes. She can't impose what's not there. And I'm sure that she has people that she has to answer to as well. They spent a lot of money on this case. It's a lot that's been invested in this case. It would look really bad for Georgia to go to mistrial route, and it would look really bad for the state for them to get terminated or whatever. So I understand the position, even though I don't like it. All right. So let's see. Here we go. Where am I? Okay, that is mute. It's mute. It's done. Turning to alleged mistreatment in front of the jury, and a judge has broad latitude in determining how to control the courtroom. Broad latitude, a lot of room, and directing attorneys to sit down when overruling objections falls within that latitude. This court will give a remedial instruction directing the jury to disregard any disparaging remarks about the counsel. That's all y'all got. You can't make them wipe it from their memory. But I mean, it's been a nice enough break. There's a new judge in town. It will give them some indication that something went wrong, and they may strike it and see it the way we see it, or may not. Nice gamble. Claim 5: improprieties in an alleged illegality of the June 7th ex parte conference. In open court, the prosecution rejected an ex parte conference with the court. The defense was therefore on notice of this request. The defense also knew that the request was not to secure immunity for Copeland, as the immunity order had been signed in open court earlier in the same day's proceedings. Even assuming a right to be present for this June 7th conference, no one on the defendant's team objected to the request or sought more information about it, thereby waiving any right to be present for that conference. For the proposition that defendants waive right to be present by failing to object after being informed of trial judge's meeting with the jury outside presence of defendants and counsel. I did see that she said that like you guys knew and y'all didn't object to it or have a motion to it. But who knew that they would be in this office talking about they think the defense is working with this team, and he sees how they're everybody guilty, and um the offer to have a meeting on the weekend and all of that, like, but he's no longer on the case. They kind of handled that, and they did tell you guys you didn't inquire any further. All right, Judge. As for the topic of this ex parte conference, defendant assigns nefarious intent to prosecutor Love and Hilton's representations about their interactions with Copeland's main counsel, Jonathan Melnick. The court at this point declines the invitation to so view their representations, but refers the prosecutors to its footnote I herein. Defendant complains that comments by the predecessor judge during the conference reveal his partiality to the state. Preterming the questionable accurateness of such characterizations, the issue has been mooted by the recusal of the judge from the case. Claim 6: illegality of the June 10th ex parte meeting. On June 10th, at the behest of prosecutors Love, the predecessor judge held an on the record in chambers meeting with Love and standing counsel for Copeland, Kayla Bumpus. Following a recess at which time Love departed the meeting, Copeland and prosecutor Hilton joined the meeting. Defendant's motions raised several challenges to this ex parte meeting. Did defendant have a right to be present? Did the ex parte meeting amount to coercion of Copeland's testimony? And did any Brady violations occur? Okay. We have some footnotes. On August 5th, 2024, Melnick supplemented the record with a statement in his place as to his representation of Copeland and addressed the asserted conflict of interest. The predecessor judge's remarks regarding outside agitators are virtually identical to the remarks he had just made on the same topic in open court. Remarks which he addressed to all counsel and which could not therefore legally include defense counsel. Defense also raises the specter of another ex parte conversation between the prosecution and the predecessor judge, or that portion of the June 10, 2024 ex parte meeting was not transcribed because the predecessor judge seemed to know that the prosecution had a list of questions for Copeland, despite there being no prior mention of such a list during the ex parte meeting. This knowledge is easily accounted for. The prosecutors had specifically referenced such a list of questions reviewed by Ms. Hilton with Copeland on the record during the prior Friday's proceedings. Thus, the innocuous source of the predecessor's judge knowledge. Did defendant have a right to be present? Defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. The initial stage of the meeting before the first break centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest and with the logistics of handling Copeland's testimony with stand-in counsel. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core, and as asserted by the prosecution, Copeland's immunity grant. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical state of the trial at which the defendant had a right to be present. Case law. Criminal defendant has a right to be present when his presence has a relation reasonably substantial to the fullness of his opportunity to defend himself against the charge, but not when his presence would be useless or its benefit but a shadow. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. Defendant is correct that there are differences between the meeting in this case and the meeting in King versus State, cited by State. For instance, the meeting in King was to secure immunity for a key prosecution witness. Footnote: the court sympathizes with Mr. Melnick's understandable indignation at having his professionalism and his loyalties to his client questioned. The court likewise appreciates defense counsel's umbrage. The issue of Brady material being granted during this ex parte meeting but not produced will be addressed below. As to the allegation made orally on Friday, August 2nd, 2024, that Brady material was revealed to the prosecution in an off-the-record conference between Hilton Bumpus and Copeland during a break in the ex parte meeting. See the court's separate court order therein. Okay, so we're picking up from, and the defense was aware that the immunity hearing was occurring. Here, the defense was not given notice of the meeting, and immunity had already been granted in a key prosecution witness. So the topic was not where the immunity was in the public interest. Instead, its topics were the adequacy of the witness' legal representation and logistics about stand-in representation, as well as ensuring the witness correctly comprehended the meaning and impact of the immunity grant. What would and would not amount to contempt of the order granting immunity and compelling his testimony, and the potential consequences of failure to comply with the order. The state's reliance on King does not demand that its facts be on all fours. The legal import of King for this claim is because a defendant's rights are not the subject matter under consideration in proceedings surrounding a witness immunity grant. A defendant has no right to be present for discussions with the tribunal surrounding witness immunity. The fact that here discussions included what testimony would subject the witness to charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what that sanction might entail. Even if incorrect, does not change the analysis. Defendant's rights were still not the subject matter under consideration. No right to be present at hearing compel witness testimony pursuant to immunity grant. Ex parte meeting at trial court's behest between court prosecutor and counsel for witness initiated after defendant and his attorney had left the courtroom during a recess at the close of the witness direct examinations and held to ensure. Lori found that because the hearing there also included discussion and ruling of the defendant's motion, a mid-trial motion in the lamine regarding the witness using street names during testimony, absence of the defense violated defense statutory right to be present through any constitutional error was waived. Here, there was no ex parte hearing or discussion of any defense motions. This analysis confirms that the key to whether the defendant has a right to be present for witness immunity proceedings is whether for some reason defendant's rights are also subject matter under consideration. Witnesses understood his deal with the prosecution and he was not unknowingly incriminating himself and understood his constitutional rights held to be an ancillary proceeding dealing only with the rights of the witness at which defendant had no right to be present. Was the witness testimony coerced? Separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has a right to a trial free of coerced testimony. Defendant asserts that certain arguably inaccurate representation made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable state of limitations relating to what crime or crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. Case law is the touchstone for evaluating claims of coercion by the trial court of a witness testimony. Case law provided another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness determination whether to testify. Here, Copeland had the benefit of counsel. The predecessor judge did not, on the whole, use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate, it was. While it is likely that Copeland was not induced by an inadvertent or other inaccuracy to testify, the cleaner approach is simply to pre-termit this issue, acknowledging past inaccuracies and advise Copeland anew. This is the course that the court has proposed and the parties have affirmed its efficacy. Was there a Brady violation? There has been a long-running and multifaceted proceeding. Challenges have been myriad and formidable. Frustrations may have been mounting while fortitude was waiting. And a needle in a haystack is not only sometimes difficult to find, but also easily overlooked. The court does not attribute bad faith to anyone on this issue. And yet, as soon as Copeland joins the June 10, 2024 in Chambers ex parte proceeding, he states, "I have never been truthful a day in my life, and I just made this statement right now." Copeland may have little credibility. He may speak in hyperbole, but the fact remains that for a defense attorney, this nugget might be a key state witness is goal. So when the prosecution not only did not reduce this statement to writing and produce it, but also asserted in court filings that the defense had no entitlement to know the contents of the ex parte proceedings, this amounted to suppression, whether willfully or otherwise, of what was objectively Brady impeachment material. The defense now knows of this statement and indeed of all of what occurred during the June 10, 2024 ex parte meeting. So y'all see that she is saying that they've suppressed and she's giving them wiggle room, whether it was willful or otherwise. They now know. The contents of this meeting were ultimately revealed during the course of trial and in time for the defense to utilize it. So the failure to produce suppression of this information does not technically amount to a Brady violation, but the fact that a violation of a defendant's constitutional rights has been averted does not, under the circumstances, provide cause for celebration. Copeland has since been recalled into open court on August 6, 2024, and in the presence of his counsel, Melnick, which also privately consulted with and advised Copeland, was provided clarifying and correct information on matters potentially impacting his choice whether or not to testify. All parties were present and consulted with the court prior to the Copelands being re-advised. What it does provide is case for sober reflection and examination of processes, procedures, and approaches that permitted this likely inadvertent but nonetheless serious Brady legal to occur. Defendant seeks as a sanction the qualification of the state's two lead prosecutors because this does not appear to the court to have been purposeful violation, but rather a negligent overlooking of the impeachment value of Copeland's in-chamber statement. The court does not order their disqualification. At the same time, the court is cognizant that defendant's liberty, as well as the liberty of his co-defendants at this trial, is at stake, that the prosecutors involved are knowledgeable and experienced, that this is not the first allegation of prosecutorial misconduct in this case. The court therefore orders, as a remedial measure, that the entire prosecution team working this trial submit to training on Brady and other professional obligations of a prosecutor. The training will consist of a video replay of training on this topic, previously presented by the Prosecution Attorneys Council of Georgia. The court will provide the video, and the viewing will occur under the direction of the court. So ordered. Wow. I mean, just wow. Just wow. They accept it. They know the violations occur. No harm, no foul. We gonna keep it moving, and they gonna watch a video. She's giving them the wiggle room of they ain't intended. They didn't mean it. They didn't mean it. They didn't mean it, y'all. Oh, excuse me. So, it's been reset. They're coming back tomorrow. The prosecution team, I mean, we'll see what they do. We'll see how this evidence goes. There are some other motions out there. They will be heard going forward. I wanted to give us some content, get the discussion going, kind of catch us up a little bit. And I guess I'm being a little bit of the devil's advocate here, that the judge is essentially in a leadership position, which they are, and she's dealing with, a member of the team, employees of the state, that they have to lay foundation, I guess, to terminate them. And this is what that looks like: verbal warning, written, write up, performance review, all of that. You did do it. We're going to do this training. They understand. They know that they need to give you guys everything that's supposed to happen. She has been very firm about that when speaking with them and telling them, and, listen, y'all at your last straw. You can tell that she's aware of the tricks. Like, even when she was saying, I don't want you getting up here and, you know, asking them about something as a way to kind of sneak it in. And Miss Love understood. She gave her verbatim because that's what she's been doing. So I think that she will govern them accordingly, but it sure would have been a win, and I wonder, would this be the standard for everyone? But this is where we are. Tr- it will trial will resume tomorrow at 8. I didn't get very much traffic over here. I'm going to look and see what it looks like in the morning, and it may be a wiser choice to just go ahead and run it on an established channel and kind of transition over here. I don't really know. So, you know, I'll see what it looks like tomorrow. And I thank you guys for joining this live, and I'm out.